You'll have to mention because Justice P. Chokia. I cannot. You'll have to take up the matter before registry. When? Now? 21st.
Item 1.
এই হেৰি পেঞ্চিল কলম খিনি সেইফালে দি থৈ দিছে মোক হাতখন ঢুকি নাপায় নাই নাই ইয়াত নাই all right yes item 1
It's not formal at register matter.
Hmm.
So, also the report matter.
yes do you have the report has been
Don't
called
have
for.
anything, Lord.
Report has called for is not received issue reminder list the matter on when do you want positively reach the matter on
28.
for report positively.
Right.
Item 2.
Do you have the report? Item 2.
Oh, Lord.
Report as called for is not received. Issue reminder to forward the report positively on
30 April.
30 April.
Item 3.
Jesus, no.
Not entered extra.
Do you have any report?
No, Lord. I don't.
Well, my lord, my lord, just telephonic instruction, my lord, please was registered.
No, at 2 I may not be there. I have to go somewhere.
Very much.
Maybe later, maybe within 4 noon. Within 4 noon, they'll get the instruction. Not afternoon.
No.
After some time then, item 3.
Item 4. Item 4.
All of day.
Item 5.
Where is your
Mm.
petition?
Mm.
It's a one-page text. I not have the person. I use number 3.
Mm.
I not here actually the husband of the is
Mm. Right.
No, accused number 1 is not the husband. Husband is Ibrahim Ali.
my lord, my lord.
Nazma Sultana is the informant, huh?
Petitioner, my lord.
Nine.
No, informant is Nazma Sultana. No?
Nazma Sultana, her husband is Ibrahim Ali.
Mm.
My lord, here what I'm referring to, one getting the FIR
Mm.
are all relatives, are all own family members. And accused number 1 is the husband, 2 and 4 are the sons, 5, 6 are the brother-in-law. Here, my lord, the specific indication is with regard to accused number 1, my lord. In the FIR, my lord, next one, page 10.
Please read the FIR.
Respectful submission is that today on 3/12/2024 at around 9 a.m. First state person, it is my husband, by entering our boundary and
No. Your husband is your Nazma. You are Nazma Sultana.
no, Nazma Sultana.
Ah.
I am Firoza Khatun, my lord.
Okay. All right. Yes.
Respectful submission is that today on 3/12/2024 9 a.m. the first and accused person by entering a boundary uncorrectly cut down a gold plate, taxi in his hands. And if questioning about what are you cutting that, why are you cutting? So that because that option had accused more than after that was the other and the other how and all the as well as where in the one might not need, we want to take
It would, of
Later, when CNR members woke up, they found a fortress that is not to be burned. Additionally, the fire expressed towards her house and damage to many items. With the help of neighbors, the fire was extinguished. Therefore, sir, I have submitted petition as I have to take next action against the next person. Lordship, I am the neighbor of the, I am the neighbor of the complainant. Recently, what happened, Lordship? I have got the certified copy of the forwarding report, Lordship. The main accused has been arrested, Lordship. Kindly reduce the ground of arrest.
Hmm.
Ground of arrest.
Hmm.
Krishna PS case number 60 of 2025.
Mm.
Ground of arrest.
Hmm.
Number one, Lordship, the appeal domain is involved in so many places with the owner of the property, with the whole of that case. Case here is India's history of lots of cases related to their family. So the victim is wanting to get married to one Prahlad Bora, Lordship, who is the husband of the victim, Property Soikia, and it is suspected that he might committed the crime involving in a criminal conspiracy with others. 3. The accused woman admitted her guilt to some extent. 4. After committing the crime, she admitted all the facts for one, Jagriti Bora and Prahlad Bora. I am neither Jagriti Bora nor Prahlad Bora, Lordship. Sufficient evidences have been found against all the accused persons. Then they arrested. Lordship, since I am the neighbor, Lordship.
In the forwarding, I have not, so see her name, Lordship, Partha, it is petitioner is
Partha Pratim.
Partha Pratim Soikia, but the forwarding is of Bobita Das,
Yes,
Lordship.
yes. I'm 42 application.
I
Main
understood.
accused arrested. He recently arrested. That's why I could not produce the
Hmm.
along with
That's
the
right.
our learned counsel, Mr.
P board letter.
P. Bodle for the petitioner, Pathaputim Suikia, who has filed this application under section 482 of the BNWS 2023 with prayer for PRS bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. KK Das, learned additional PP Assam. The allegation, the FIR unfolds about arson in the informant's house. 2 scooties have been burned to ashes as alleged, and the building was about to building was about to be damaged by the fire, but somehow the building was saved. The petitioner is a neighbor and he is apprehending arrest in connection with this case. The learned counsel for the petitioner has submitted a certified copy of the forwarding report of forwarding the prime accused in connection with this case, which is marked as X and will form a part of this record. It is submitted that Srimati Bobita Das is the prime accused who has already been forwarded to custody, and the reasons are and the grounds of arrest are also mentioned in the forwarding report. It appears that interim bail may be granted to the petitioner. Call for the city list the matter on. In the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation, and the petitioner shall appear before the IO on every fortnight till completion of investigation.
I think I can.
On breach of any of the bail conditions, bail order shall automatically stand cancelled. Page 14.
Page 14. This is the above, I'm the owner of the airport residing in DM Road. This is vehicle is financed by Chola Mandala, for which money which I'm dealing with. But due to unavoidable circumstances, I was bound to sell the aforesaid vehicle to one people, son of so and so. That's the day at 39 AM. I got a call from one person named Abdul Abdel. My aforesaid vehicle is being loaded in one trailer and was crossing Bilasi Para area of Dhubri district. And when I saw it, I came to know that people had sold the same aforesaid vehicle to one Saka law. without my knowledge. That's moreover the said vehicle is illegally financed and the said person are very much well aware of that. Though they probably or by wrong means have changed the number of the vehicle before BC so and so to AS 26. So I'm trying to stay away from accounting at all these I came to go from the now the vehicle is in custody of Pilasi Para. That's the permanent person have not paid me the full amount and I often they are trying keep and that my money has the extra switch. This is the ending. Now, why not we come to page 24? This is in the sale agreement in the form of affidavit. And the sample is an affidavit. But from page 25, if lordship sees, is the FIR informant Vinit Dani. And I am the applicant Sofiko Rahman. This is the same vehicle, my lord. The deponent or number one or seller, clause number 2, my lord, is the registered owner of a Tata LPK so and so vehicle bearing registration number is 04 BC 96 engine number chassis number so and so, so and so. Number 3, that the deponent number 1 seller had decided to sell his said vehicle to the deponent number 2 purchaser on a consideration of 16 lakh, excluding installments which is to be borne by deponent number 1 seller. The seller has to pay. Number 3, that in consideration of rupees 16 lakh only paid by the deponent number 2 purchaser, the deponent number 1 seller by cash, the deponent number 1 seller acknowledges the same. This entire sale amount has been paid to the FIR informant and it is acknowledged. And the rest of the installments, since it's a hypothetical vehicle, the rest of the installments are, as per this affidavit, to be borne by the FIR informant himself. So there is no money which I am to pay to him. I do not owe him any other. Now, my lord, what happened in this case? I was also in need of money after purchasing. So I had sold it to Shah Alam had taken. Of course, it is under. But therefore, the necessary formalities. Thereafter, what Shah Alam did, so as far as the allegation against me in the FIR is that I had sold it to someone else. And there are bank transactions to prove as per UPI, I was paid a money of rupees 50,000 and the rest of this.
Yeah, from the FR, it is looks that lordship, you have stated that the registration number has been changed. And number is also given lordship to what number it has been changed. Moreover, lordship, section 3(5) is there. So common intention is also there. So he cannot state that the petitioner, he is not aware of that lordship. It will investigation that will come up in the investigation whether he is involved or not. So lordship, without CD it is difficult.
But not in this case, my lord, my bank transactions, everything, my lord, I have to produce before the investigating authorities. That I can do, my lord. It is only a question of into the record.
You do not have the onus, actually, the onus is on the person Vinit.
Lordship.
He has to pay the bank loan,
Yes,
repay the loan.
Lordship.
And then without repaying the loan, he sold it to,
No, that is another part, lordship. But the registration has been changed. This registration number, that
can
is
change.
lordship.
Somebody likes vanity numbers. Can change.
But otherwise, leave it to lordship. Lord. My
Hard
objection is
Third learned counsel, Mr. P.D. Nair, for the petitioner can be granted writing interim. For the petitioner Mohammed Sofiq Rahman, who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so-and-so PS case under so-and-so sections, heard Mr. K.K. Das, learned additional PP Assam. The allegation against the petitioner is that he has fraudulently sold a vehicle purchased from the informant without informing him. Full stop. It is alleged that the vehicle was on finance. A vehicle was purchased through loan from financial company, and the vehicle number was also manipulated and changed, and thereafter, with a view, with the object of selling the vehicle and fleeing the state, the petitioner has sold the vehicle to another person without the knowledge of the informant, and thereafter manipulated and changed the number of the vehicle. It is further alleged that the petitioner is yet to pay the remaining, yet to pay some amount to the informant. Learned counsel for the petitioner has drawn the attention of this court to annexure 3 of the petition, which is an agreement for sale, and the petitioner has accepted the consideration of petitioner and the informant has accepted the consideration of rupees 16 lakhs for the vehicle number AS 04 BC 4996 from the petitioner. The petitioner is willing to cooperate with the investigation. The learned additional PP has raised objection against the prayer for interim bail. I've considered the submissions and it appears that interim bail may be granted to the petitioner. Call for the city list the matter on. In the event and in the interim and in the event of his arrest, the petition shall be allowed on bail of fees 30,000 adjustable security of like amount to the satisfaction of the arresting authority, under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. And the petitioner shall appear before the IO on every fortnight till completion of investigation. And the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled.
He's from Sagar and the.
It will last out to delete koida. Jurisdiction of the court to delete koida.
Item 7.
After some time, okay. All right, after some time.
Item 8.
Mm.
Yes,
Mm. Mm.
Sir, with due respect, I submitted that on 24/1/2025 at around 5:30 p.m. My minor daughter, 17 years 6 months, went missing from the house.
So almost all the accused person who is approached, my lord,
Yes, housing, yes.
housing, my lord.
Many people have, I have not granted bail to all.
But to some, my lord, I have annexed those orders. Actually, my lord, the petitioner before your lordship now, my lord, was at that time he was working under Dulal Day.
Just a moment. I ready.
Was not there, Lordship, and on the day of accident, I was in Guwahati. I'm a driver, and I was with my car owner in Guwahati, Lordship.
My lord, here we have received that case there, my lord. Here, as per PM report, my lord, it was not ascertained, my lord. And hereafter it was sent for Victoria, my lord. And Victoria was sent for FSL report, my lord. And on FSL report, my lord, it was gave positive test for organophosphorus insecticide. And another found, my lord, here. Gave positive for ethyl alcohol and its amount was estimated 22 ml, the blood matter. Thereafter, he is the my husband matter. As per my lord complaint, my lord, he was the husband and he, my lord, actually he was actually Sahidul Islam, my lord, but military as a my lord, Pritam Daha, my lord. Then thereafter, my lord, from the military, my lord, several persons were arrested, my lord, and suspicion against him also regarding his involvement.
Lordship, I'm prepared to appear before the IO. Kindly give me protection.
Ethyl alcohol is not poison. But that insecticide is poison.
And he was found lying in the matter, roadside.
Lying on the road. He's the husband?
No,
What is
Lordship,
his
I'm
name?
not the husband.
What is his name?
His name মানে Sahinur Islam মানে প্রীতম দাস এটা হাজবেন্ড
Huh?
Sahinur Islam
Okay.
এলাস প্রীতম দাস married to
No,
Married
no,
to
Lordship.
that victim?
my lord.
No,
husband,
I'm not
eh?
the husband.
He's the husband.
আমরা statement of the complainant
Hmm.
Ito ay. Yan. Ito technically affair. Chief, there was the lower affair was there, but he is not husband. Krishna is not the husband. of the victim.
I have found all other statement except the statement of the complainant.
Right.
Please help me find it.
Right.
All statements I have
Right.
found that there are two FSL reports.
See,
Hmm?
what is regarding that not
No,
case
no,
that-
that is negative.
Right.
So one is that insecticide is found
Oh.
and the methyl alcohol also has been found. The third part is negative.
minor. That is negative.
After that, absolute report is clear.
Just a nearest bill murder case, I'll have to check.
minor. But thereafter, I will look at complainant, thereafter, I will look at it.
Okay, then what do you say?
My lord, that is, investigation is just going on, my lord. And that, my lord, from the death of occurrence of the several attempts were done by the police part, but there is some overburdening the investigation. Some hostels were made by the police part. And the investigation is going on.
4 accused have been arrested.
My lord, that is later part, my lord, later part for payment.
Heavy plus. तो उसमें पर डाउनलोड कोई प्ले फोकस नहीं I think can be granted. Can be granted.
My lord,
You, according to you, cannot be granted.
my lord, to me, at least, it's an interim protest of here, my lord. So, they will come out, my lord.
Lordship, any condition may put, Lordship, I will fully cooperate. Lordship.
Allegation is against, he also may be, my lord, involved in or not, my lord. But to me, at least, it's
Whatever winter him.
my lord. Let him appear and therefore he disclosed why he was.
Lordship, refund may be given, Lordship.
My lord. If no matter found after years, otherwise, he may disclose why, how he was involved. Regarding.
Lordship
The
may,
later part is here, my lord. When he was found in a condition, my lord. As per the attestation of the but earlier part is not here. Whether she conduct herself or by the.
Well, she has a head injury. He has a head injury. Then they have given poison. She has a head injury. Then they have given poison where she was found. Then they have given, maybe she was drinking also.
Lordship,
There's insecticide, there's alcohol, and there's a head injury. I think he can be granted. She was found somewhere else, and they were already caught and reported, and his name has come later. Can be granted later. Although it's 103, can be granted.
My objection is there, my lord.
Yes, it's your objection. There's a head injury, no doubt.
My lord, head injury and investigation is also going on.
But she was found somewhere else and they have admitted. 4 of them have admitted
Fine.
that she was there.
Fine.
So why to pull him in? Third learned counsel, Mr.
P. Boiragi.
K. Boiragi.
P.
P. Boiragi for the petitioner. Sri Sanidul Islam alias Pritam Dekar, who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. B. Sharma, learned additional PP Assam. The allegation against the petitioner is that he is involved in the death of the victim X. The learned counsel for the petitioner has submitted that it is true that he had an affair,
Gotcha.
that the petitioner had an affair with the victim, but he is not involved with her death. I have also scrutinized the case diary. The merits of this case are not brought to the fore. I have also scrutinized the postmortem report. Investigation has progressed substantially. The appraisal report is also received.
My submission is
Raised objection, Likhina, raised objection. It appears that pre-arrest bail may be granted to the petitioner. I have considered the submission that the petitioner is a local resident and he is willing to cooperate with the investigation. আগত লিখি দিবাচোন এই এফআইআৰ আছিলে বুলি আৰু তাতে আৰু এটা সেন্টেন্স লিখি দিবা that the prime accused have already been forwarded to custody এনেকে লিখি দিবা. So they are not on bail.
Fine.
They are still in custody,
fine.
4 of them, and there's 1 head injury.
My submission is that bail shall be granted at this stage when the investigation is going.
No, can be granted.
Fine.
I think can be granted. It लिखिला no? Considering all aspects, the petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the inspection of the arresting authority. Under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. The petitioner shall appear before the IO on every fortnight till completion of investigation. The petitioner shall not leave the jurisdiction of the court without prior permission. The petitioner shall not exercise threats to the witnesses or try to influence them on breach of any of the bail conditions. The bail order shall stand cancel automatically. Send back the CD.
Highly.
I checked what has happened. Coincidentally, my lord, names are different, district is different, but same set of facts. This is not a person.
Okay.
Otherwise, and I checked the other bail order also. Lordship will go by the materials and the.
Panbazar. Panbazar.
Let them go to the LCR. After vacation.
But your lordship will kindly give me these 2 girls and I'm in outside suffering from my 2 daughters are suffering from thalassemia, my lord. If this is my because
Thalassemia.
thalassemia, my lord. Imagine, but your
Okay,
lordship,
Here you only and then I'll keep the other part reserved, then what to do?
your lordship will reject my interim prayer, my lord. What is there, my lord? I will not keep me hanging, my lord.
No, there's no interim prayer.
No, I have made an interim prayer.
Finally,
No, your lordship will say, if I'm not, it's not that this is the only case where I'm seeking an interim bail or your lordship is granting
this is
interim
not
bail.
interim prayer. I want to dispose it finally. I have got a scan copy.
My
of
lord,
the chat.
your lordship will ask me to abscond from the police till my friend has the time to look
That is
for the
what
case.
you've been doing so far.
No, I've not been able to come with my 2 sick daughters to Assam, my lord. I'm outside with their treatment, my lord. And this is a case, my lord, where charge sheet is submitted. I have not been shown as an absconder in the search sheet. My lord, if the police on the dictation of some extraneous consideration will call for interrogation of this case, my lord, what is this? This is not how the criminal justice system function in our country, my lord, with utmost respect, my lord. And this is not my fault. I don't hunt for bench, my lord. Let me make it clear, my lord. Never in my 31 years of practice, I have hunted for bench. It is because of your lordship's order at page from 104, 105. That's why this matter is before your lordship. And then your lordship has sent it that I will not take it because this bench was not allotted to me.
To place the submission and you cannot compel me to hear only you and pass an
No,
order.
I'm not, see, I
And I
cannot
want to-
compel your lordships on it.
finally, why you are
Malad, that is
insisting
the
on
Malad, that is the
interim?
submission made from day one, Malad, and your lordship has your lordship may kindly recall, your lordship.
Of course, why should I hear on interim? Why?
But your lordship will then take it up at two. Let him have a glance to the records, Malad. Your lordship, because this is one of these cases.
You see, they are also overburdened, you see.
Malad, I understand. Everyone is
How-
over.
how-
Malad, this is the concern of the liberty of not only the father along with the two daughters, Malad, who are sick, Malad. That's why I'm praying. Otherwise, I could have, this is an NDPS. If it was a normal NDPS case, Malad, who will pray for interim bail in a anticipatory bail application and interim prayer in an NDPS case, Malad? Scan records are there. Your lordship will take it up at 2. After that, your lordship finds that there are materials against me. Your lordship will reject my anticipatory bail.
I have granted
that-
bail.
Well, I'm just submitting one thing, my lord. In this case, started submitted in the year 2022, my lord. Well, still then, my lord, he has not been arrested, my lord. Till today, my lord. It is almost.
And now
my lord,
suddenly he has
Police-
come up with.
police is now summoning me.
At this 11th hour, it's
Yes,
such an
this
emergency.
Malad, your lordship will not, your lordship.
Immediately after reopening, my lord, we'll go to. Today, we have not gone to, my lord, only we have seen that NCB has been shown as a, my lord, opposite party. It is, we thought that, my lord, it is a case of NCB, my lord. Because lordship kindly paid the, my lord, cause this, my lord. It's all PPS and NCB, my lord. It is why we have not paid this kind.
See, these days, I am taking up bail and they are only dealing with bail and only CDs. And that too voluminous CDs. Give them some time.
No, it's not that I am not giving time, my lord. I had filed, your lordship will look at the date of filing of the petition, my lord. Date of the filing of the petition. I don't blame this court, my lord, 2
And I
times.
also go through the.
Yes, my lord. I'm not blaming my, your lordship
No,
will
no,
reject my prayer, my lord. I don't hunt for bench, my lord. Let me make it clear. This 2 times,
Who's asking you?
no, my
Who
lord,
said
no,
so?
your lordship has told me that why you have not prayed for the bill before
The
another court.
first day before Manas Johnson Pathak.
I prayed. Then I was did just point out that these are the orders granted by a coordinate bench of this honorable court. So the matter has to be listed before that bench. Then it came 2 times before your lordship. Your lordship was not willing to take it because your lordship told that I cannot take up this matter because I am not taking up NDPS matters. That's why it went back twice to the registrar. My genius has to run from desk to desk in the registry to get this matter listed. And today when I come, they say that we are confused whether it is NCB or state. I pray before this honorable court that it will be taken up to. But I don't, but I go to the orders of this court, your lordship will take it after vacation. But I'll not praise for interim.
Okay. Heard learned senior counsel Mr. BD for the petitioner and learned additional PP Mr. RJ Borua who has submitted for time to go through the trial court records. List the matter on petition episode.
We are obliged, my lord, for giving us
Now
a
you
patient here.
got me wrong. I have said first day when you were to ask for interim before Justice Manas Ranjan Pathak. There you got me wrong.
No, no.
Because you didn't ask for interim there and why you asking
No,
for
no, no,
interim
no,
here?
my lord. I asked for
This is
interim.
what I'm
I
saying.
prayed for interim.
And
They
then
just say
me
the
wrong. I
learned.
didn't know that this case is pending
No,
in
my
High Court.
lord, it's not that. My lord, I asked for the interim. I asked for the interim before the judge. They just said that now there is an order of the
So
Supreme Court.
I was thinking that why everybody is pressurizing this court for interim
No, no,
and
no,
not
nobody
other
is pressuring.
courts.
Nobody is
This what
pressuring.
I'm thinking.
But nobody is pressuring. It's your lordship's discretion, my lord.
It was the advertisement made by the informant. The accused purchased the car and paid an advance of ₹4 lakh. Thereafter, the when the accused came to know that the vehicle is hypothecated, and when the informant was trying to sell the vehicle to another person, we have filed an FIR that has been charge sheeted also. In that, after filing of the FIR, the seizure has also the vehicle has also been seized. Now, after a period of 2 years, the police has sent me a notice. That's why I have approached this honorable court. I'm on interim also. I have appeared before the IO.
So you can hear, before the IO, statement record with us.
Money
Third
suit
learned-
H. Agarwal.
Third learned counsel Mr. H. Agarwal for the petitioner. Raja Chakraborty, who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so-and-so PS case under so-and-so sections, heard Mr. K.K. Das, learned additional PP Assam. It is submitted on behalf of the petitioner that he had purchased one vehicle from the informant, and he already paid already paid rupees 4 lakhs in advance and the vehicle was agreed to be sold at rupees 9 lakhs. Later, the petitioner learned that the informant has sold a vehicle which was on hire purchase
Hypothecated,
or which was already hypothecated to the financial company
no, hypothecated with
with
Chola
the bank.
Bank, in Chola
With the
Investment and
with
Finance Company.
with the financial company, with the finance
Finance
company.
Company.
Full stop. The petitioner,
Also after
it is
some,
some, it's okay. It is submitted at the bar that it is submitted by the learned additional PP that the petitioner has appeared before the I. I have also scrutinized the case diary. The petitioner's statement has been recorded. He has not violated any bail conditions. Considering all aspects, the interim order dated 13/3/2025 is hereby made absolute.
obliged.
Send back the CD.
May I please, your lordship? In this matter, scan copy was called for lordship. It's a charge sheeted matter, lordship. The allegation initially case was registered under section 448 and 366A, lordship. While the charge sheet was submitted, then 376 was added, lordship. And
Three seventy six was added.
yes, 376 was
140.
added.
Is my new ground. Otherwise, the offenses are under wildlife
Yes,
protection.
yes.
Well, new ground, I don't have, my lord, he's still not cooperating, my lord. He's absconding, our officers are searching for him. My lord, that part, that is up to your lordship, because the ground they have annexed, I don't find it too specific, because the medicines, Signoflam is a painkiller, Zerodol is a painkiller. Offered to well-equipped hospital to consult with a neurologist.
Neurologist.
It's a prescription from 3/12/24.
No, the earlier one is of 3/12/24 and the second one is of 10/3/25. Second last one.
We did. I cannot follow a word.
That on left side
Consult with neurologist. This much I could understand.
referred to well-equipped hospital to consult with neurologist. Chronic lower back pain.
What is the punishment? 10 years.
10 years.
That amended section.
Yes, my lord. Non-bailable also, my lord.
Earlier, the accused
What is the offense?
offense some
Tiger, purportedly when a leopard or tiger bones were recovered from.
not from my custody.
Which page?
The offense report is just page 12. There are two accused. One is Basudev Roy, who has already been granted bail by the.
You have the
Paragraph 6 of lordship's order, my lord, and page 20. He was named.
earlier I have rejected.
Yes,
Yes.
rejected.
You have this. What do you have? You submit offense report.
Yes, my lord.
You submit offense
Yes,
report.
my lord.
You have it with you.
No, my lord, I have to bring it immediately on opening. I can bring. 21 is
This is
lordship.
motion or hearing?
Bail hearing.
Hearing.
Otherwise, lordship, the order page 24 is paragraph 6. He was incriminated, my lord. Lordship has
Here-
gone through the case material statement, everything.
He has been named by the accused number 1.
This is hearing. So why don't we have the offense report?
Well, this case basically didn't show us our name. This is third time it is coming, my lord.
Okay, okay.
So that is the issue.
So we'll call for the offense report.
21st, I can bring it. my lord.
Yes.
In the meantime, some protection is possible.
Rejected bill 1, my lord. Violate offense.
Yes, yes.
It's
Call for the offense report. List the matter on. Item 24, item 25.
May please, lordship.
Hmm.
This case, my lord, case diary as well as statement of the.
The whole case was lost, my lord. Page 17, last but, my lord, one para, my lord. Sinmoy Das and his companions' action are not only unethical, but may also, kindly have a look, my lord. He was on impression that they may also constitute a criminal offense, my lord. Now kindly see, my lord, this FIR was lodged on around 11 PM on 28th, my lord. And within 10 hours, my lord, this present accused petitioner was arrested. So now, my lord, during investigation, my lord, after his arrest, he prayed for bail, my lord, because of his marriage, my lord. And he was granted bail, page 24. Kindly have a look once, my lord, for 7 days, my lord. So thereafter, he immediately surrendered. That part, Lord should find page 25, my lord. That interim bail, my lord. I'm being cryptic because, my lord.
Page 25.
Yes, my lord, page 25. That third para, my lord. Because of time constraint, my lord, I'm also going a little faster, my lord.
Mm.
Page 25. Lord has seen, my lord.
Where?
That third para, my lord.
Chinmay Das, yes.
After,
One left.
yes, my lord, 7 days, Lord has seen, my lord. Page 25.
For his marriage.
Yes, my lord.
Okay.
Thereafter, my lord, he was asked to surrender. Last line, my lord. Fix 11.3, my lord.
Mm.
Lord has seen, my lord.
Yes.
There, kindly have a look at page 26, my lord. Then he immediately surrendered on that day, my lord, after his marriage, my lord. Now, my lord, thereafter his bail was rejected and anticipatory bail was granted to his mother, his wife, my lord. But his father's was rejected because there was some amount went into his account, my lord. Now, my lord, what happened, my lord? I have given the chart, my lord, from page 35. Kindly have a look, my lord.
Page 26 is his surrender,
Yes, yes.
date of surrender.
Yes, yes, my lord.
Okay. Page, which page?
My lord, page 35, my lord. Here, lordship would find, my lord, that amount, my lord, that first line, my lord, which was credited into his account, my lord, that was 14 lakhs and 5,000, my lord.
Mm.
And what was returned back, kindly see, my lord, that is also through debit, my lord, through online my lord, banking transactions, my lord. That right hand side, 2234, lordship, see. And next page 36, my lord. This is another account, my lord. Here also 10 lakhs and 8 lakhs was returned, and that whole transaction amount, my lord, I have, my lord, narrated in para 7, page 7, para 10, my lord. My lord, total amount he took, my lord, that is around, my lord, 24, my lord. Oh, I'm sorry, my lord. He returned around 30, my lord, 30 lakhs. And from the petition informant, he took around 22 lakhs 34. So 8 lakhs 11,000, my lord. He has already returned that, my lord, what is the, my lord, investment, my lord, amount. And, my lord, here, my lord, it is not a, my lord, unregulated account, my lord, unregulated trading like Badzak. Although Badzak isn't given, my lord, it is regulated because it is through that Dhan app, my lord. It's a mobile application, my lord.
What?
Dhan, my lord, DHAN, Dhan app, my lord. And it is, lordship knows, my lord, investing in stock market, my lord, it is not illegal, my lord, legal. And, my lord, what happened? There are risks, my lord. Lordship knows, my lord. Sometimes it goes up, sometimes down, my lord. So there was an apprehension that he may flee away and he may not return the money. And for that offense, my lord, also there is a specific, my lord, section.
This Deepsika Bhuiya, ACS,
Yes,
Chiranjeev Deka, ACS, these are all involved in this case.
My lord, that one is his wife, my lord. So
Okay.
she was granted anticipatory bail, my lord.
Okay.
That also I have annexed, my lord. Not the order, but the step.
He is related to Chiranjeev Deka?
My lord, possibly friend, my lord. Possibly, my lord. Or acquaintance from the same area. And the informant is also from the same area, my lord. And all those banking, my lord, transaction I have annexed from, my lord, that page 37 till, my lord, page 120, my lord. And here, my lord, grounds of arrest is there. I'm not going into that, my lord. And section 48 also violated, my lord, two friends. I'm not on that, my lord. Now, length of detention and the fact that, my lord, his conduct, my lord, he surrendered, my lord, and he won't flee away. And the money which he took, my lord, that is true, my lord, legally, my lord, in account, no cash transaction as per these documents. And if your lordship kindly have a look at one section, my lord. Here, lordship, kindly have a look at one section of that.
This account is Axis Bank account.
Yes, yes.
And this has been done through Dhan app.
Dhan app, my lord. Yes, yes. Kindly have a look at, my lord, that section 4, my lord. Because they have attributed section 21, that is violation of section 3. Kindly have a look at section 3, my lord.
Mm.
Section 3 is regarding unregulated bank, my lord, deposit schemes, my lord, which are illegal, my lord, unregulated. And kindly have a look at page, my lord, that section 4, my lord.
Mm.
Fraudulent
Yes.
default in regulated deposit schemes, my lord.
Mm.
Your Dhan app, my lord, and Zerodha account, it is not illegal, my lord. And we have narrated, my lord, in our petition, my lord, how it is done, my lord, because you have to give your, my lord, the person has to give his Aadhaar card, bank details, then PAN card, even photographs, digital signatures. And my lord, in Zerodha account, he has to give his through webcam, my lord, the image, his face, my lord, recognition that is given, my lord. So there is no illegality. And my lord, here, if your lordship will look at that 4, my lord, of that act, my lord.
4 years.
Yes, fraudulent default in regulated deposit schemes, because these are not unregulated. Security market, all are regulated, my lord. So here, no deposit taker while accepting deposit pursuant to a regulated deposit scheme shall commit any fraudulent default in the repayment or return of deposit on maturity, or in rendering any specified services promised against such deposit. So if you assume, my lord, the offense would possibly be under this section 4. And for
7 years.
my lord, that is
7 years.
bailable, my lord. Kindly have a look at.
Bailable?
Yes, yes, my kindly, no, because these are regulated schemes. That's why the act itself shows that it is bailable, my lord. Kindly have a look at that 22 is that punishment, my lord, for
Yes, yes.
section 22. So that
Oh, yes, I got it. Offenses to be cognizable and non-bailable. Yet
except,
notwithstanding, okay.
yes, yes, 28, yes. Lots of possibly seen it earlier. So 22,
No, I haven't seen earlier. For the first time. I've
Achha,
seen.
22 and my lord, then 28. Now, my lord, considering all aspect, my lord, money also returned, my lord, on suspicion it was granted, and he surrendered, my lord. And one aspect, my lord, they did not investigate first, my lord. Within 10 hours, he was arrested. The arrest memo also we have annexed, my lord. So they did not investigate right away. There are so many judgment, my lord. Arrest should be the last option, and some investigation has to be there thereafter arrest. So not going into that section 48 and 47, my lord, on the length of detention, and he surrendered back, my lord. Kindly, my lord.
Yes.
My lord, we have discussed the case already, my lord. Investigation is still going on, my lord. And so far, the investigation carried out by the IO, my lord, sufficient material has been collected. Because, my lord, he has also admitted that, my lord, he has taken money, my lord. My lord, with the assurance that, my lord, he will pay, my lord. Suppose a person invests, my lord, 1 lakh rupees, my lord. He assured that he will pay, my lord, 1.5 lakh. But what happened, my lord? After depositing the 1 lakh money, my lord, he used to pay, each person used to pay, my lord, 50,000. After that, he never paid.
Stop paying. This is what has been done all the time.
Yes, and my lord, in the case, my lord, his account has been, my lord, his, my lord, account statement has been filled. And from the account statement also, but it is clear that, my lord, the witness, other, my lord, 15% of the witnesses, my lord, they used to deposit money in his account.
Yes, I'm on. Kindly see it.
And my lord, he used to give the check also, my lord. Suppose if I invest 1 lakh rupees, my lord, he used to give a check of 150 lakh. But my lord, after that, my lord, he used to pay 50,000, my lord. But after that, he stopped paying. This is the, my lord.
See the CD. Let me see the
Yes.
CD.
On the merit, my lord, because stock market goes up and down, my lord. I am not on that, my lord. Kindly see the length of detention, because he was arrested, my lord, on 1/3/25, my lord. And although 42 days, but in between he was granted bail for 7 days. So it will be around 35-36 days, my lord, in custody, my lord. And no police custody also sought subsequently, possibly, because first there was a prayer, my lord. Thereafter, he was granted that 7 days order, and possibly no police custody prayer. I may be wrong if it is there, my lord. I am not that sure. Possibly not taken, my lord.
His name is Sanmoy Das, no?
Sinmoy, yes, my lord. Yes.
What is the apps? What are the apps? Dhon
My lord, that is Dhan app, my lord. Dhan app, lordship, that we have, my lord, elaborated that, my lord. Lordship, kindly have a look at para 8, page 6, para 8, how it is done, my lord. It's a
You
mobile.
have named another app also, no?
Yes, Zerodha account is also used, my lord. More, Zerodha account is much more, my lord. Dhan app is a new app, my lord. Zerodha, my lord, everybody possibly uses it, my lord. Zerodha.
Okay, I'll come back in person order.
Well,
Can you write it here, sir?
Case that I
Can be.
case that I have less mileage.
Mm.
One of that.
You have stated,
Lots of
there are evidence,
yes, materials are there, but
yes. Money is also too much.
money is a huge money.
But I'll
Question is
grant
that my
bail.
lord, all personal money is a hard earned money.
Yes,
If
true.
he has taken money, he has to return it. He cannot misappropriate money, but my objection may be recorded money.
Yes.
Still investigation is continuing.
But learner counsel, Mr. A. Chaudhary for the petitioner Sinmoy Das, who has filed this application under section 483 of the BNSS 2023 with prayer for bail as is behind bars since how many days? 1/3/2025 in connection with so and so PS case under so and so sections. Heard Mr. R.J. Borwa, learned additional PP Assam. The learned additional PP has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. Many people have invested and their hard-earned money have been siphoned out by the petitioner and his associates. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. The learned counsel for the petitioner, petitioner naam to likhi diba, Sinmoy Das, has submitted that. The allegation of siphoning of money to illegal trading app is absolutely false. The petitioner has received money which is shown as annexure, shown at annexure page 16, no?
my lord. Transaction page 35, my lord. From page 35.
Page 25, no?
35, my lord.
Page 35. Receive money under transactions are shown at annexure
I'm sorry.
G. Is it G?
My lord, G, my lord. Yes, my lord.
Annexure G of the petition. The bank statements clearly reveals that the money has also been paid back, no?
My lord.
Paid back to the investors. The money was received through what? Zerodha.
It was used in Zerodha and that Dhan app, my lord.
The money was here, money
Invested.
was transacted through Zerodha and Dhan app, which are registered
My lord.
in the in the SEBA.
Security market.
SEBI, no?
SEBI, sir.
Which are registered in the SEBI. And this is not a case of illegal trading app.
Right.
The petitioner, although booked under the BADS, no?
But yes, my lord.
BADS Act,
My lord.
is booked under bailable offense.
It will be, it is non-bailable, what has been attributed, but it will be bailable so far the allegation goes, section 4.
Bailable offense.
My lord.
Is liable under bailable,
Right.
is allegedly liable under
Right.
bailable offense and not under the sections registered against him.
My lord.
Investigation
Madam.
is still under progress, but it can be said that investigation is,
Yes, yes. No, only the,
investigation, I have considered the progress of investigation. It appears that bail may be granted to the petitioner. The petitioner is willing to cooperate with the remaining part of the investigation. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the CGM Kamrup.
Kamrup, my lord.
Learned CGM Kamrup under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall refrain from such
My lord,
activities with which is alleged. The petitioner shall not leave the jurisdiction of the court without prior permission on breach of any of the bail conditions. the court is at liberty to cancel the bail granted to the petitioner.
Kindly-
In fact, the CD.
But it will be 35 days because 7 days he was on interim,
I have given the date.
my lord. And in fact, all unregulated cases, my lord, it went to the CBI, my lord. This case still Assam Police, my lord.
Oh, yes, yes.
That is,
Correct, correct.
yes. Much obliged, my lord.
True.
This matter, my lord, will take some time, my lord.
Hmm.
It's regard to long incarceration behind the bar, NDPS case, my lord,
Hmm.
and 47 and 50 of the CRPC, my lord. Article 22(1).
Hmm.
Shall lordship hear today or it will take some time,
It will take some time.
my lord?
Today I'll have to complete
That,
everything and I'll have
that's
to
why, my
go.
lord, I have
So if I hear, then I will have to.
at least 20-25 minutes.
Yes, cannot hear today. Learned counsel for the petitioner has prayed for adjournment.
Can it be, my lord, on 22nd, my lord?
Then please be ready on
On
22nd.
27th, my lord.
Release the
22nd.
mat- huh?
22nd.
Please release the matter on, okay, on 22nd. On 22nd, if we.
Fine.
Yes,
Yes, yes, yes.
That matter, my lord, your lordship may be remembering, my lord. That's one journalist, my lord. His brother, he was released from bail next
That's
on the same night this person was. The whole allegation is by civil matter.
Remember.
Yes, madam. Civil matters, madam, power of attorney, allegation, power of attorney was given. On the power of attorney, Procedural land cannot be, my lord, sold also, my lord. So whole thing is civil matters, my lord.
I did not remember the case, but I know his journalist brother.
But
I
your
remember.
lordship, when other day, your lordship, I pressed for interim, your lordship said no. If city does not come, I'll see. But now city has come, my lord.
We have received the city, my lord, already 1 hour ago, my lord. We
Ah.
reviewed the case diary.
No, my lord, 1 minute, please. But my question, my lord, on the face of the FIR, it is civil matters, my lord. I am on my lord. It is for that regular bail, my lord. Further custody is required. This is one thing.
1 hour ago, he's received the CD. Let me see the volume.
My lord, the volume, my lord, this one.
We are actually missing some points also. Last time he missed some point
So
because
he is very expert, otherwise he can see more in 10 minutes.
I-
It's a
These
question of
points-
expert, my lord, when the city was called urgently, my lord.
Yeah.
Fixing today, my lord, so it is also my duty to, my lord.
Yes, my lord, yes.
Access this honorable court, my lord. So, my lord, as per the investigation carried out by the IO, my lord, what I found from the case diary, my lord, it is in the very initial stage, my lord. And I have seen, my lord, the complainant and his wife's statement recorded, my lord. Apart from, my lord, all other seizure. Whatever, my lord, in this case, this writer also, my lord, it is statement. My lord, who write the deed, my lord, the power of attorney, LS power of attorney, my lord.
No, sir.
He has been arrested, my lord. Now he has implicated him to Abu Roman. Apart from the, my lord, apart from the extension of the complaint. So this is
I am only, my lord, civil, my lord, just have a look to my lord. I will not take much of the valuable time. So page 20, my lord. In support of that, I will see one of the judgments, my lord. I have the honor to state your lordship, page 20, my lord.
Ojai PS case number 90.
Yes, ma'am. Yes, page 90-25. Section, my lord, breach of trust, estate, my lord, and yeah, that's the one. Your lordship, kindly see page 20. Your lordship got it, my lord. Your lordship may read it, my lord. Should I read, my lord?
Then you can read.
I have the honor to state that I have been deceived, cheated by the accused on 7/1/25. I told Abdul Sattar, I am not Abdul Sattar, my lord.
Hmm.
And that I intended to sell my land, Tauzi Patta, Tauzi land, which cannot be sold, my lord. Accordingly, Abdul Sattar, the third person, took me to Bilal, I am Bilal Ahmad, son of legislation, and told me that Abdul Sattar told me that he would make all arrangements for sale of my land, also would do the paperwork of the office of Circle Office. But he further told me that I would have to put my signature on a deed of power of attorney, which I would enable him to search for buyer for my land. After 2 days, he took me to Shankadanagar court, Fajai, and got a deed of power of attorney prepared by a notary, but did not give me any copy thereof. So he does not have copy of the power of attorney. Therefore, he did not make any further communication with me. That on 10/3/25, some people came to see my land. When I asked them, that told me that Bilal Ahmad had sold the land to them for a consideration value of 3 lakh. This is the allegation against me. When the people came, they say that I have sold the land to somebody else with 3 lakhs rupees, my lord. Having learned this, I went to the house of Bilal Ahmad to know whether he found any buyer for land or whether he had sold me the land. At that time, Bilal Ahmad told me that he did not know me and that he did not get any power of attorney from me. Informant himself said that he does not have power of attorney. I said I do not know and I do not have the power of attorney. Then I asked Bilal Ahmad to pay me my dues and told him that otherwise I will lodge a case with the police. Thereafter, upon making an inquiry, I came to learn that Bilal Ahmad is a land broker and that he has done such thing with many people. Land broker's case also filed against so and so. Other day I have shown to your lordship. That case, nothing, no materials against him, my lord. On 15/3/25, he accompanied by some unknown person came to my house, made a threat to me not to raise the matter with the police. When my wife raised a protest, then they touched my wife, my maid, so and so. Now they have come to. So, my lord, on the basis of the further custody is required, and I am only on that, my lord. Only allegation is that suppose it is correct, my lord. Even if it is correct, my lord, just a judgment, just a copy, my lord, your lordship, only one paragraph will do, my lord. On power of attorney, my lord, so long as judgment is there, by power of attorney, one cannot sold, a thousand and cannot be sold at all, my lord. Now, your lord, kindly paragraph 6, my lord, page 6. This court recognized that, your lordship, paragraph 6, that although the inherent power of a high court under section 482, that is my quashing, yet the high court must not hesitate in quashing such criminal proceedings which are essentially of a civil nature.
This, I know about it. just
Then 7,
It has come up recently, no?
yes. Then paragraph 7, my lord, essentially the present is, yes, essentially present
Civil
dispute.
matters must not be treated as criminal matters.
My only question, madam, I live to subject matter, the friend says, man, as to further consider the requirement, heart patient, my other day also I have stated your lordship, man, one medical, prescriptions of the matter.
Where is the medical prescription?
So already put on the, he in charge headmaster of the school, my put under suspension also, my
Suspended also.
automatic 48 hours, but he automatic suspension, my. So I think nothing, he cannot.
48 hours, yes, automatic.
Yes,
suspension.
my. So, man, I put any condition, my
Okay,
lord,
okay.
further custody.
Already suspended.
Secondly, my lord, let me submit, my lord. Secondly, my lord, he's also, my lord, charged in another, my lord, Uday police station case, my lord. The offenders are there, my lord, 406, 409, 420.
So that is maybe,
My lord, being a, my lord, headmaster or teacher in a school, my lord, what is his role, my lord, in, my lord, executing or, my lord,
Yes,
taking the
yes,
power?
he's fine.
no, that is there, my lord, he will face the
My
consequence.
investigation is very initial, my lord. It requires further investigation, my lord. And other my materials are yet to be collected.
No, it's okay. Tozy land cannot be sold.
Yes.
Whatever in power of attorney, with or without,
That is, my lord,
Tozy land cannot be sold legally. He can hand over possession
Yes, ma'am.
that part of
through
the
an
investigation-
affidavit, which is done usually.
Yes, ma'am.
Through an
that part of the
affidavit, he can hand
investigation
over.
is yet to be done, my lord, that part, my lord. Whether it is handed over to, my lord, somebody else, if it is handed over to, my lord, suppose to another person, my lord, that person will have to be examined, my lord, to know, determine. So these are the
It's already been
investigations yet-
suspended.
Yes,
My lord, my strong objection may be recorded.
yes, madam, yes.
This can be recorded.
Obliged,
But London Senior Counsel, Mr. H.R. Chaudhary for the petitioner, Tabur Rahman, Muzumdar alias Muhammad Bilal Ahmed alias Bilal Master, who has filed his application under section 483 of the BNWS 2023 with prayer for bail, as is behind bars since 1/4/2025 in connection with so-and-so PS case under so-and-so sections. Heard Mr. R.J. Borua Learned additional PP Assam. The allegation against the petitioner is that he has induced the informant to execute a power of attorney, and thereafter this power of attorney was used by him, and the land of the informant was sold to a third party for a consideration of rupees 3 lakhs. The learned counsel for the petition, the learned senior counsel for the petitioner submitted that Tozy land cannot be sold. It is a civil matter in the garb of a criminal case, and the petitioner's dispute can be resolved through a civil case, a civil case. Full stop. It has been held by the Honorable Supreme Court in Naresh Kumar and another
Paragraph
versus
7.
the state of Karnataka and another in connection with SLP criminal number 1570 of 2021. It has been observed here that in 2 lines,
Paragraph 7, my lord.
Paragraph 7.
Essential present
observed
dispute,
Seven.
not
7 and 8.
8 only.
that criminal proceedings cannot be taken recourse to as a weapon of harassment. The learned additional PP has submitted that there are incriminating materials in the case diary against the petitioner. I have also scrutinized the case diary against the case diary, and there are incriminating materials.
Very initial stage of the investigation.
The implementing materials in the case diary against the petitioner, and investigation is at its nascent stage. Only statements of 2 witnesses have been recorded so far.
Recorded, and other witnesses are yet to be recorded. And the point was just implicated thing,
It is, no, incriminating materials I have stated. I have also scrutinized the case diary. There are indeed incriminating materials in the case diary against the petitioner. However, I have considered the submission that the petitioner is a heart patient.
Yes,
Where is the patient?
yes, I have given page 41 to 49, madam. Medical prescriptions are there, madam. Page 41 to 48.
Petitioner is
Last
a
time
heart
also, you all-
patient.
yes.
And annexure,
Annex, madam, 4, 5, 6, madam, 6.
6 series.
6 series, madam.
and the annexure 6 series are the medical documents of the petitioner. It appears that further custodial detention may not be required to further the investigation, considering all the full stop reader, the petitioner is a government servant who has already been suspended. Government servant, no?
Yes, yes.
Head teacher.
In charge headmaster of the
Or
school,
the petitioner is the in charge headmaster
of the ME
school,
school, madam.
who is already under suspension.
Page 99.
And is thus not a flight risk. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the,
CGM हो जाए शंकर देव
under the condition that the petitioner will appear before the IO on every
15
fortnight
days,
till
madam.
completion of,
Twice in a month.
yes,
Yes.
on every fortnight till completion of
That's your question.
investigation. The petitioner shall refrain from such activities with which is enlarged, alleged, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner. Send back the CD.
Obliged to us, much obliged.
Is item 27.
Oh, yes, madam. But in this case, I think my dear will step back, call for the CD, my lord.
Yes.
For petition.
Call for the CD, list the matter of
Yes,
28.
it is Pan Bazar, my lord.
Hmm?
Pan Bazar, yes, Pan Bazar, yes. Pan Bazar, yes,
25 April, 25.
25. Obliged to us. This case, my lord, your lordship, I'll take your lordship, kindly have a look to page 22, my lord. Page 22. This is an FIR filed on 6 July 24. Your lordship, kindly. 6 July 24. This was lodged by one Mayanabala Rai. In this case, my lord, present my lord, informant is number 1, accused number 1. Allegation of my husband committed suicide because of this person, my lord. Your lordship got it. Because my husband committed suicide because of the reasons by the compulsion made by accused number 1. Page 23, my lord. Yeah, page 23.
Uttar Kumar Pradhani.
Uddhapura Pradhani.
He is the accused
No,
of what?
sorry, Joydev Rai.
Joydev Rai.
Yes, Joydev Rai. Now, Joydev Rai, your lordship, can you see page, High Court, page 30. Page 30, my lord. They got bail, in that case, they got bail, my lord. Joydev Rai alias Madhavbandhu Rai. Your lordship got it, my lord. Now, this Madhavendra Rao now filed the present case, my lord. Against us, against me as well as that lady, my lord. Saying that we have, my lord, extorted money and we made attempt to extort money from them for different reasons. So this is the background of the case. Present FIR is paying 40 money. It is a complaint given to the CR case, my lord. CR case was given to the CGM,
Page 14.
page 14. This was your lordship kindly see, this is the FIR. That accused number 2, my lord, page 17, your lordship kindly see, my lord. Two accused here, one is Uttam Kumar, present petitioner, second is that Mainabala, that my lord informant. Page 15, Mainabala accused number 2. Now your lordship will find page 17. Accused number 2, Mainabala, I know the case, my lord, because since it has come from motion, my lord. My prayer would be that, my lord, your lordship kindly call for the city in the interim, my lord, on the face of it, my lord.
Yes, so what do you have to say?
The case that will be called from, I don't know, examine. Because there are allegations made in the, against the.
But extortion, my
He has
lord.
been FIR and accused person.
Yes, yes, that is both, my lord.
We'll examine the case that.
In the interim, my lord, my lord.
But what Uttam Kumar Pradhani has to do?
Uttam,
He is
but
the
he is the
petitioner.
person before lordship.
He's what he has to do in this case?
He is to do
With
because
that other case,
in other case, they call
suicide case,
other informant also here, my your lordship accused. Your lordship kindly see. Page 14, my lord.
informant is accused, but not this person.
No, not
Uttam
but
Kumar
but
Pradhani.
both of them are made by the informant. Your lordship kindly see. Page 14, accused. Your kindly see accused, my lord.
Why?
Uttam Kumar and
He is not
Mainabala.
related to the other case, no?
No, other case because Mainabala is here added to me. They say both Mainabala and myself. Both together we are trying to extort money from them, my lord. That is their case. Paragraph under your lordship, the category stated, my lord. Paragraph 2. That the accused number 2, Mainabala had was a false case. Thereafter, my lord, these things will come. Both of them are made money accused here, man. And he has stated about his own brother, my lord, your lordship. Page 7, page 18, paragraph 7. Very important, my lord. How he is. A complainant begs to state that all the transactions were made through the employee of the accused number 1,
But
namely.
his name is not here, Uttam Kumar Pradhani.
It is there, my lord. Lordship may kindly come to.
Where?
number 7,
1,
my lord.
2,
No,
3.
page 14, madam, page 14. My name is number 1. Page 14. Accused number 1. What?
Oh, yes, yes.
Second is Mayabala guy. Next page. Accused number 2.
Oh, these are witnesses, okay.
Those are the witnesses.
So how you are related to Mainabala, right?
We are from the same place, madam, the same place.
Place only?
Yes, and your condition by page 18, paragraph 7. It will make clear, madam, how false case is it, madam. Page 18, paragraph 7.
We'll call for the CD.
No, that is there, madam. You certainly you also call for the city, madam. On the face of it, madam, the extortion, madam.
Short date, short date. We'll
I
call for
lift
the
your
CD.
lordship, madam, but only thing I think.
Immediately after vacation.
Immediately after vacation. Call for the CD, list the matter on.
Obliged your lordship.
May it please your lordship, my lord. It's a lordship will find the FIR at page 8, my lord. Small FIR, my lord.
Yes, please read.
Respectfully submission is that on so and so at 8:40 PM, my dumper had some mechanical problem and I parked the vehicle in front of the garage named so and so at so and so place. However, around 10:45 PM, I learned that an unknown person had stolen my vehicle from the place, my lord. So in the instant case, my lord,
Dumper stolen. We'll need the CD, no?
no, I'm not the
Car theft.
the person have been arrested, my lord.
Arrested.
Arrested that your lordship will find, my lord, at page 14, my lord. page 14, my lord, the one Barek Ali has been arrested, my lord. Now here, my lord, the petitioner before your lordship, my lord, we are the maternal brothers of that accused, my lord. So I have made a categorical statement at page 4, paragraph 5, my lord.
Associates are yet to be identified.
Yes, but we are not, my lord. We are brothers, my lord, and we reside in the same campus, my lord.
Let us call for the CD.
My lord, in the interim, my lord, because we reside in the same campus, that's why we have been. I have made a categorical.
If nothing comes up, I will definitely grant you
Yes, my
bail.
lord, that's true, my lord.
Car and motorcycle theft. For the CD list the matter on very short date,
My lord,
25th April.
my lord. I am obliged, my lord.
Made resolve.
Yes.
Anticipatory bail application of. Here, my lord. Very long FI, my lord. It starts from page 19, my lord.
Hmm.
And specific, my lord, 4%, 5% are named, my lord. Here, my lord, regarding, my lord, they were found to be collecting money, my lord,
Hmm.
from trucks, my lord, which were loaded with limestone, my lord. It comes from Meghalaya area, my lord. And while entering, my lord, Assam, my lord, this side, those persons, my lord, if you also read the whole, my lord, they are specifically named, my lord. And they have been arrested also, my lord. Now,
Why are you apprehending
yes, my
arrest?
lord, he is a, my lord, assistant enforcement inspector, my lord. And my lord, his duty, he possibly, maybe some direction or duty or something like that, my lord, because policemen have visited his residence. And in fact, he is on leave, my lord, for the last 1 month. Kindly have a look, my lord. Those certificate we have annexed, my lord. This page 22, it starts, my lord. Page 23. Thereafter, my lord, from page 23, my lord. Kindly have a look, my lord. And from 17/3/2025, he is on leave, my lord. For 45 days, my lord. Because severe knee issue, my lord, he can't walk also, my lord.
Where? Page
Page 23, my lord.
Page 23.
My lord. My lord, yes. That was applied, my lord, on 7th, my lord. And 17/3/2025 to 34/2020. It should be 25, my lord, but wrongly it has been stated 24, my on medical ground. Thereafter, again, my lord, page 24, my lord.
Digitally signed by on 7/4.
Yes. Yes.
How? Ex post facto. What kind of leave?
Government procedure, my lord. There was page 17. Kindly have a look another, my lord.
That leave was already taken in advance and thereafter.
Yes.
Just I'll read the subject to.
Yes.
Spring the Amrut is allowed under Rule 9 the leave only for 45 days. All in future tense and then he is giving his signature in past tense.
Page 24 once, my lord.
Okay, on leave report. Okay.
Yes.
On leave form.
24 is that forwarding of the
Mm.
on leave application, and my application 25, my lord. Page 25, my lord. On 17/3, my lord, it was applied, my lord. Maybe as a witness also, my lord, but since my lord, police personnel came, my lord, and government employee, my lord, so some
I'll
apprehension.
just read the FIR.
My lord, my lord. Yes, my lord, kindly below. Type copy of the regulation, no? Follow, sir, dictate document, follow. No? No, given it. Okay.
Everything is written in past tense. The incident also on 5/5/2025.
Then GD entry of 4, my lord.
Yes. Yes, yes.
Then the case diary we call for, my lord, we have to examine the case diary, my lord. Because although he has not been named, my lord, but what, for what purpose,
Not
my
been
lord?
named yet.
Maybe the statement of the, my lord, other witnesses, my lord, has indicated him, my lord. So, my lord, let the case diary be called for, my lord, immediately after declaration.
Yes.
Kindly interim or government employee, otherwise I would not have prayed, my lord. And already on leave, kindly see.
No,
my lord.
but he was not on leave during that period.
Yes,
The
yes.
time of offer.
Yes, yes, madam.
Question is 45 days leave for, my lord, knee pain, my lord.
My lord,
45
kindly.
days leave for knee pain, my lord.
No, no, knee pain means, my lord, is severe, my lord. It may require replacement also, my lord. And he was on leave, kindly see, my lord. Because it's from 17/3 to 34, my lord. Not 5, my lord. 34 means this month also, my lord. Now on leave, my lord.
Question
Now
is,
on
my
leave.
lord, without there being anything, my lord, police will not certify.
My lord, he is a government employee, my lord. Kindly see, and not a single whisper in the FORD, my lord, FIR that somebody else is involved, my lord. Specific allegation against 4 persons, 5 persons, my lord, and one instance has been recorded. Kindly see in that instant, my lord, incident also, nothing against others, my lord. Those 4 or 5 persons, they were extorting money, my lord, and on the road itself, my lord, they were apprehended by the investigating agency, and no role has been attributed to any other person. And definitely Lordship would call for the case diary, my lord, only because of his that medical leave and government employee, my lord. Kindly, my lord. Kindly, with all respect, my lord, because not a case at all, my lord, for my lord requiring custodial detention at this stage, my lord. Kindly, my lord. If he,
Let it come out 22nd.
but if he was not a government employee, my lord, I would not have prayed, my lord. With all respect, my lord, because kindly have a look.
Yeah.
Kindly have a look, my lord, because specific allegation against this 4 or 5 persons, my lord, and it doesn't state that, my lord, that the other persons are involved, my lord. Kindly see, my lord. If they're unnecessary, because VU holidays also, my lord, and knee problem issue, he's on earned leave, my lord. Now also on leave, my lord. Kindly, my lord, I would not have prayed otherwise, my lord. And because no role has been attributed to any other person, my lord. And departmental rivalry knows, lordship knows, my lord, if he's inside, my lord, his whole service career will go, my lord. If he's detained, because Bihu days, my lord, let him be at home, my lord, with all respect, my lord. Kindly, my lord. And lordship may fix it any day, my lord, for the Bihu itself, my lord. Kindly, if possible, my lord. Because otherwise, I would not have prayed, my lord, if there was some allegation against other person and against this particular person, my lord. He is on leave, kindly see, from 17 till 30, my lord. Means, my lord, this month also till 30th of this April, my lord, he is on leave, my lord. And he can't move.
Let it fix on 22nd, my lord.
No, why he is insisting, my lord, I don't know, my lord.
One day, my lord, we have saying, my lord, because there is a.
No, one day, no,
22nd, my lord, will produce the case.
well, it's your lordship discretion, my lord. I leave it to your lordship discretion, and if possible, kindly, my lord, because otherwise I would not have prayed. Government employee, no allegation against any other person, He is on leave, my lord, and he might, my lord, he might require also knee replacement. I am not sure about that, my lord, might, my lord. And otherwise, why he would have, my lord, sought for earned leave, my lord, on 17.3 itself, my lord. Was he aware of this whole incident, that this incident will come and then he have to come and go for anticipatory bail, my lord? That is not the case. It's a genuine case, my lord. He is on leave, my lord. And now also he is on earned leave, my lord. And if he is arrested and detained, my lord, he'll be suspended, my lord, unnecessarily, my lord. Kindly, my lord. And he will cooperate, my lord. Lordship may direct him to appear tomorrow or every day before the investigating agency, he will appear, my lord.
How will appear, my lord, with the knee pain, my lord?
Then how you can arrest him in his that situation? Kindly, my lord, have some mercy, my lord, on this man, my lord, if possible, my lord. Otherwise, I would not have prayed, my lord. And I have read it, my lord, the whole, my lord, FIR, my lord, twice, thrice, my lord, not a single line against others, my lord. That there other persons are involved, my lord. Kindly, my lord. So sections of law also, my lord, those extortion and theft, my lord. That this limestone may be theft. So regarding theft, it won't come. And regarding extortion also, my lord.
Not happy with the
Yes, I have
leave
also seen.
letter.
My lord,
Why is it signed as 17.4? I'm really not happy with the leave letter.
which, my lord?
7.4 or 17.4, I don't know.
No, 7.4 was this
7.
government order, my lord. 7.4. So earned leave, my lord, he sought for possibly as per government norms, my lord, he have to apply, my lord. He applied it on 17 March, my lord. And that was forwarded. Kindly have a look at page 24.
On
my lord.
19th.
17.4, it was forwarded. Kindly see, my lord.
On 19th, and immediately after the date of the incident, that leave was granted.
No, my
I'm
lord.
really not happy.
No, my lord. I'm sorry, my lord. Kindly
The
see.
incident occurred on 5.4 and the leave was granted on 7.4.
No, he is already on leave. Kindly see. That is the letter.
I have seen.
Page 24, kindly once, my lord.
Page 23, I'm not happy with.
No,
page
24,
23.
kindly have a look, my lord.
I've seen.
Forwarded on 17, my
I
lord.
think we have applied for leave like
Yes.
manner.
No, 17.4.
I know how,
Yes.
as Das will also know that.
My lord.
How earned leaves are applied and how earned leaves are granted.
Yes, my
You
lord.
will also know.
Kindly, my lord, because
He's also there.
genuine paper, my lord. Let them.
So I'm not happy with
No,
this.
my lord, we'll give all these
Page
documents.
23, I'm not
My lord,
happy.
we'll give all these documents to the investigating agency. Let him verify, my lord. We'll give him all these documents, my lord.
I am not happy. Investigating agency, what will they be?
But that is
How happy will they be?
no, we'll produce it, but if there is any illegality, my lord. That may be recorded, my lord. We'll trace it before the IO, my lord. With all respect, my lord. A government employee, his service will go, my lord. Not a single iota against any other person. Section won't be attracted, my lord. Knee problem, on leave. Kindly, my lord. Bihu is also there, my lord.
See,
Yes,
because of this, you are an astute lawyer.
No, my lord.
Ingenious, very
No.
intelligent lawyer.
No,
See,
no,
because of
we are
this
trying.
7.4, you have annexed all the application.
Yes. Yeah, we have to, my lord. So, my lord, we have to show something. My friend,
Leave order
my friend has done
7.4.
it. Adopted. My
You
friend.
have to annex all this
Yes,
application
my friend has done
that
it, my
it
lord.
was made beforehand.
Kindly, my lord.
I don't know. Really, I'm not really happy with the leave order.
But
Page 23, only page 23.
But we'll produce all these documents.
Other pages I'm.
No, we'll produce
agree.
these documents before the IO. Let him verify, my lord. Let it be on record. No. Let it be on record, my lord. We'll produce this document also, my kindly, my lord.
Okay, then I'll ponder over the matter
If possible.
for some time.
Because,
Yes,
definitely.
Of course. That is why I'm
Yes,
taking.
balance of little bit
Yeah,
in
that's why
our.
I'm taking it
Yes.
to ponder over without
My lord,
rejecting it straight away.
My lord.
I'll ponder over the matter.
My lord, with all respect. If possible, my lord, Bihu and all.
Yes.
The thing is there. And Lordship may direct that all these documents will give it to the IO. He will verify. He'll verify, my lord. Let him verify, my lord. And if these are fake, case will be registered against the petitioner, my lord. Cannot be fake, my lord. With all respect. Obliged.
May I please also? Anticipatory bail application, my lord. FI is page number 12.
Page number
Page
12.
12.
Yes.
Mary.
Hmm.
To the officer in charge, so and so. With due respect, I beg to state that today on 25/3/2025 at around
It is motion or bail hearing?
motion, matter. At around 8 a.m. when I along with my mother, father, and my younger sister on the way of our original home situated at Nilak, Misamari, Saporigaon, with our own vehicle, the accused person above named surrounded us near their house and took me away from the vehicle and assaulted me on head by a Nongolamari Buddha and injured me badly and trying to assault me with a sharp weapon. And somehow I saved my life. And when I trying to save my life, cut injury occurred in a part of my right finger and also snatching a 20,000 only from my pocket. On prayer of my parents, somehow my life was saved. This case was registered under section 117 of 2, non-available voluntary causing hurt up to 7 years, and the snatching. Lordship, may kindly come to the page number 26. This is my affair, my lord. Actually, what was happened, I have taken some money from the informant, 99,000 rupees as a loan, my lord. I have begged all the money, 99,000, but after receiving the 99,000 rupees money, he demanded for another 1,70,000 as interest. Lordship, may come to page number 26, my lord.
Your FIR has been registered?
Not yet registered. Mary,
So
my whole transaction.
why has your not FIR been registered?
But they have not yet registered, my lord. I have stating it here that that today on so and so at around so and so time, one Sri Zunaram Aranda, this is the informant. His father so and his mother visited my house asking for giving the interest amount and put on altercation. And on emotion, he came forward towards me with a dao carried on his back. I fled away from the place and somehow saved my life. Lordship, may calmly come to the page number 18. B series. This is the Google Pay. Through Google Pay, I have paid the money. The first line to Junaram Arandhra. This is the informant, 30,000 from Mr. Deepak Tipomia. This is the petitioner. If entered B series is the altogether 99,000 rupees paid to the informant. He never claimed for the interest. That's why he filed the case against me like this, my lord.
Yes.
The second FIR, my lord, has been, my lord, alleged to be lodged by the, my lord, accused person therein, my lord. Because there is no endorsement that, my lord, it was received by the police station.
Not registered.
Not yet registered.
Not received and registered.
And secondly, my lord, there are allegations, my lord, so that the case that an injury report may be postponed.
So far as the transaction is concerned, they are directly paid to the informant, my lord.
Okay, then let him appear.
Lordship.
Hard learned counsel Miss P. Bora, no?
P. Bora.
For the petitioner, Deepak Timoria.
Deepak Tipomia.
Deepak Tipomia. Only one petitioner.
One petitioner.
Who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so-and-so PS case under so-and-so section. Heard Mr. R.J. Borua, learned additional PP Assam. The full stop, the learned additional PP has raised objection against the prayer for interim bail. The allegation against the petitioner is that he has attacked the informant with a bamboo pole, with a bamboo fence, with a fencing post, with a fencing post, and caused injuries on his head and tried to attack the informant. And also tried to attack the informant with a sharp weapon. The learned counsel for the petitioner submitted that there was money transaction between both the parties and the petitioner has paid the money, but the informant demanded rupees. The informant demanded a commission against the money, against the money borrowed from the borrowed by the petitioner, and he lodged a false FIR against him. It appears that the petitioner may be granted interim bail as is willing to cooperate with the investigation, call for the city list the matter on. In the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. The petitioner shall refrain from such activities with which is arrest. The petitioner shall appear before the IO on every fortnight till completion of investigation. On breach of any of the bail conditions, bail order shall stand automatically cancelled.
Public.
Mm.
Wait, please, Lord.
You have the CD?
Well, scan copy is there, my lord. The regular bail
NDPS.
application, my lord.
NDPS.
No, my lord. But the petitioners are facing trial, my lord, under 302.
Okay.
Well, this matter went up to the Supreme Court, my lord.
Mm.
So, my lord, what happened, my lord? Initially, my lord, the Sessions Court granted bail. When, my lord, the charge sheet was submitted, the Sessions Court granted bail. Against that, my lord, the informant challenged in the High Court. High Court cancelled the bail order granted by the Sessions Court. Thereafter, my lord, the petitioners approached the Supreme Court. Supreme Court issued notice and also stayed the order passed by the Honorable High Court. Thereafter, when the trial proceeded, there are around 32 listed witnesses. Out of the 32 witnesses, 27 witnesses have been examined, including all the independent witnesses, seizure witnesses done. Now, subsequently, my lord, this matter again came up before the Supreme Court. Supreme Court upheld the order passed by the Honorable High Court and directed the petitioners to surrender before the trial court. Now petitioners have surrendered, my lord, and in the meantime, my lord, and yes, Lordship may kindly see the order of the Supreme Court at page number 70.
Page number?
70.
Page number 7. Okay.
70.
17.
70.
Page number 70. Okay.
Yes.
Mm.
And the relevant paragraph is at page point number 6. Next page 71. Notwithstanding the present order, the petitioners are at liberty to apply for fresh bail after examination of the key witnesses, including the seizure witnesses. So the Honorable Supreme Court granted us the liberty to file for bail once the seizure witnesses are examined and also independent vital witnesses, including the key witnesses are examined. Now, my lord, I have prepared a chart at page number 10, my lord. Page number 10. These are the witnesses who are yet to be examined. Page number 10, my lord. 1, 2, 3, 4, 5.
All right. Okay.
These are all, my lord, FSL, CDR witnesses, IO, and OC, my lord.
Okay.
So, my lord, considering the liberty granted by the Honorable Supreme Court, we have paid for bail. That much, my lord. And
Okay, yes.
My lord, the outcome, my lord, is a such that case, my lord. So, Lord, to bring this matter, my lord, as far as material is available in the case. Although, my lord, at this stage, my lord, cannot scrutinize the, my lord, evidence recorded before the trial court. Now, my lord, out of, my lord, 32 witnesses in the charge sheet, my lord, 27 witnesses already examined, my lord. Last PW 27 was examined on, my lord, 3/3/2025, my lord. So now, my lord, only 5 witnesses are left, my lord.
all these objections were raised before the Honorable Supreme Court, my lord, and Supreme Court, after perusing the entire issue, my lord, granted us the liberty. Otherwise, my lord, this liberty will become infructuous. So, and the petitioner is a registered medical practitioner, my lord, and there are no instances of any hampering or tampering with the evidence, my lord, during the trial. But considering that, my lord, and also since the liberty
Is he a
is there-
doctor?
Yes, doctor, my lord. Petitioner number 1. He has already been suspended, my lord. In the light of the Honorable Supreme Court's direction, my lord, that much, my lord. I'm not on merit.
No, I'll have to fix this for order. I cannot pass today. I'll have to fix this matter for order. I
My
don't have
lord,
time.
peruse it and my lord will pass the order, my lord. I
Today,
have nothing more to say, my lord. Yes.
today I cannot pass. I'll have to fix this for order. I don't have time today. I'll
My-
have to read all this, everything. I'll have to read Supreme Court's order. I cannot pass any order today.
But my lord, I have nothing more to say. My lord, the only thing is that Supreme Court categorically stated that once the seizure witnesses are completed, along with key witnesses, So seizure witness are all examined.
No,
my lord.
I'll have to pass an order.
Yes,
saying
yes,
this.
Lordship will see and
It has gone to the Supreme Court.
Yes, yes,
it has
Lordship
come
will-
back
yes,
again,
yes.
High Court has, so I
yes,
have
yes,
to
Lordship
read
will
again.
examine and pass an order, my lord.
Today I cannot pass. I cannot. Not possible for me
My lord.
today. Will not be able to complete today.
Secondly, my lord, pursuant to the Supreme Court order, my lord, they tried it, proceeded expeditiously, my lord. And out of 34 days, 27 already examined, my lord. And last witness examined, my lord, on P3, my lord. Till now, it's more than, my lord, for more than near about 40 days, my lord. It then might have, my lord, other witnesses also maybe.
No, no,
examined, my lord.
till date, my lord, I have the present order, my lord. No, no witness have been examined. So Lordship will
Witness,
fix
my
it for
lord.
order, my lord, on 21st, my lord.
On 21st, I cannot because I am nobody. I'm going home. Nobody's coming with me.
My lord,
Tomorrow early in the morning, I'm leaving for home.
my lord. Then 22nd.
How can I pass order on 22nd? I have other judgments also.
But will it be fixed? Will it be fixed for delivery of order, my lord?
I'll fix it for delivery.
Yes, that's what I'm submitting, my lord.
My head to date বিচাৰিছে তেওঁ।
Yes, delivery of order,
Delivery order তেওঁ 22 তাৰিখ বিচাৰিছে।
my lord.
Not on 22nd. I have other work
lord.
also, all pending
Then
work.
any, my lord, any
You
advance
look at
date.
the congestion in this court. You look at the congestion
My
in
lord,
this
my-
court. Every evening I'm till every evening we have been typing orders one after the other, are unable to complete it.
As your lordship
Just look at
wishes,
my
my lord. Yes,
disposal.
yes. Yes,
Just look at my disposal like a machine industry. I'm disposing cases, not like a human being.
and before
Give me
vacations.
also some
Yes, yes.
space to breathe.
And before vacations, my lord, many matters are listed also.
Hmm?
Before vacations, my lord.
Yes, yes.
Sir, by humble submission, by the editors, Lordship will make an observation, my lord. Will hamper the either way. May hamper the trial also, my lord. Which may hamper the, my lord.
I'll fix it for order or we'll fix it for hearing one more.
My lord, I have nothing more to submit, my lord. Lordship may fix it for order. Highly obliged.
Heard both sides list this matter on. It will date the DA due. 20. Oh, 25th of fine there.
My lord, the matter before the trial court is fixed on 24th. So any date before that, 23 or 24.
We'll fix it before 24th.
My lord, highly obliged.
24th আগত বুলি লিখি থৈ দিবাচোন।
Item 33.
My lord. In this case, my lord, the petitioner's charge sheet was submitted by showing as absconder. It's going to come, my lord. Instead, the matter will be listed. They take time to produce the scan letter, scan report, my lord. Now, case is this, my lord. The petitioner was charge sheet is submitted by showing the petitioner as absconder. Then summon was issued. After receiving summon, I engaged counsel. My counsel appeared. You must have kindly see order, page 20, my lord. Page 20.
Yes.
Page 20, the cognizance has been taken, my lord, on 26/7/2023. Cognizance has been taken. Summon has been issued. After receiving summon, I page 22, my lord. Order dated 4/7/2023. I also appeared. I accused number 2. Accused Hikmat Ali also absent with a step by petition. In the meantime, what happened? He filed a quashing petition here. So that is why that petition has been allowed, my lord. Next, that kindly see page 39, page 23, order dated 23/9/2024. I also filed petition. I am not absent, my lord. But now I want to appear personally before the honorable court. And since I will appear personally before the honorable court, then I will be not be grant bail because section 304 is there. So, my lord, I will appear, but no unbilled, nothing has been issued. Summon stage, case is in summon stage, my lord. So I will appear, my lord. Let me granting bail. I advise the petitioner that quashing, there is no chance for quashing, my lord. I annexed to his order, my lord, quashing.
No, NBW has been.
No, nothing.
What do you have to say, PP?
Page 28, last order, page 28.
Last parameter, remaining two accused, namely Swensu are absent, as are not returned, issue fresh summons. So summon is that matter is fixed on 19/5/2025. So I'll appear, my lord.
There is no stay order in the quashing petition.
Yes, no, that is, I also advise that my petitioner that there is no chance for a quashing. There is no chance for quashing. That is why this petition is.
There is
effective.
no stay order of the
Yes,
quashing
yes.
petition. Ma'am. And there is no, not any relevance to the quashing petition. which
Yes,
is
ma'am.
there. Because quashing is different, but if
Yes.
quashing is allowed, then matter would have been
Yeah,
different.
ma'am.
Now, he has been shown as an absconder in the search court, but he is not appearing in the court, my lord, and he is taking time, my lord. Taking that, my lord, quashing petition is pending.
No, now I want to appear, madam. Now I
Okay,
want.
then I'll pass an order, you appear that,
I will.
you apply for bail, that bail, regular bail, it will be considered by the
No,
court.
madam.
304B,
Yes, madam. There is a
304B.
similar matter, madam. 302 matter.
Person has died.
Yes, 302 matter. This novel court granted bail, madam. Other two events, coordinated.
302, I'll not grant bail
302 also.
to absconders.
These two order also can.
Except when there is nothing in the case diary, I'll grant bail. When Sasi is submitted,
no.
I won't grant bail to absconders.
Yes.
302.
No, after receiving someone, I appear through counsel, madam. My counsel appearing, madam. Next order is also can see. Honor Justice Suikia. Because only problem is that 302, I will, since summons has been, I will appear, my lord, but the CJM has no power to grant me bail, my lord. He has no power because case has not been committed. It is a session terrible case, my lord. Only, my lord, I will appear. I will do the quashing, but I advise the petitioner to would do the quashing petition. Because there is no chance for quashing, my lord. It is wrong advice has been given, my lord. It is-
304.
Another order also. 302 is here. Warrant not issued. PN also not
Warrant
issued.
is not issued, then, my lord, where is
I will
it?
appear. I will
He
appear.
can
I file a
appear-
petition.
He can appear, my lord.
Yes.
Then there is some direction that he wants to cooperate with the investigation.
I will appear. I
Cooperate with
will regularly. I will appear regularly, my lord.
Because, my lord,
Because
No
this
warrant
novel
has
court,
been
this
issued.
novel court, I am not understanding. But this novel court, several cases pass order, my lord. In 3 cases I given. Other many cases, this one considering that facts, my lord. Because since CJM has no power, he cannot. If I appear personally, he send me to a jail, my lord. Yes,
Learned
no.
Counsel Mr. J. Ali,
Yeah,
J. Ahmed
J.
for
Ahmed,
the
right.
petitioner. Which one? Hikmat Ali,
Here, Quantal.
who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with PRC case number 1900 of 2023 under sections 304B 34 IPC. It is
Pending in the court
submitted,
of.
it is submitted on behalf of the petitioner that he has earlier preferred a petition for quashing quashing the charge sheet,
Yes, that's the entire proceeding.
quashing the entire proceeding, but he is willing to withdraw the petition for criminal petition with prayer for quashing the entire proceeding as there appears that he is apprehending that there is no there is no scope for quashing. The petitioner is willing to cooperate with the trial. He has been shown as absconder in the charge sheet. He is willing to
I ask someone, I will appear.
he is willing to appear before the court and cooperate with the trial. And the last order has been annexed as of the last order passed by the trial court or by the jurisdictional court has been annexed as annexure.
Annexure 9, page 28. Annexure 9.
Annexure 9 of the petition, which clearly reveals that on 3/3/2025, summonses have been issued against him. The
No,
petition,
no, other persons. I will appear.
summonses have been issued against the,
Other persons.
then what about
Paragraph 4, my lord.
other persons? Only
Yes.
other
No,
persons.
paragraph 2, Hekmatal is absent with steps.
Okay,
Paragraph
summons have
28.
been issued against the other accused, whereas the
Petitioner file a
petitioner
petition.
had,
Petitioner file a petition with state.
petitioner had preferred a petition for adjournment. As the case is pending in the court of the CJM Borpeta, the petitioner is apprehending that he will be forwarded to custody. Considering all aspects, forwarded to custody, লিখিবলৈ full stop দি দিয়া. I have considered the learned additional PP has raised serious objections stating that the petitioner has not cooperated with the investigation. He is with- Oh, cooperate with the investigation only.
Yes.
Cooperate with the investigation and which and thus charge sheet has been submitted against him, showing him as absconded. The petitioner is not entitled to pre-arrest bail owing to his conduct. I have also considered the submissions at the bar with circumspection. It appears that interim bail may be granted to the petitioner as he is willing to cooperate with the trial. I have also taken a pragmatic view. The petitioner is thereby
Regularly.
directed to appear before the learned Chief Judicial Magistrate Borpeta, and the learned magistrate and the learned court may grant bail to the petitioner with on his executing a suitable surety of rupees grant bail to the petitioner for rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned court. The court may also impose conditions to secure the attendance of the petitioner.
Item 34.
In item number 30, madam, reserve the order. If Lordship suppose call for a case, we have to.
No, I'll not reserve. I have not reserved the order. Huh? In my chamber only, I'll send back the case diary.
But madam, we have to write the mother in the case diary.
Or if I call for the case diary. Oh,
Lordship done interim also, madam, we have to call for the case.
yes, yes.
Otherwise also we have to call for the
Yes,
case.
yes, you'll have to call for the
So
case
that
diary.
may be fixed, madam.
Date the video too. মানে হেৰি কৰি দি দিয়ে মিলাই দি দিয়ক মই কি কৰিম এতিয়া ক'বতো নোৱাৰো ঠিক আছে Yes.
Well, I have received an instruction from the SP. After receipt of the FIR, some inquiry has been done and the case has been registered for the FIR information. Can you take the instruction, serial number 5?
5, no?
5 in the second page. On the basis of the findings of the preliminary inquiry, a case has been registered at Namtola Police Station by Namtola PS Police Station case number 7 of 2025. Under section 329(4), 305A, 351B, PNS.
No, my lord, your lordship, I want to take your lordships to the constitutional bench judgment, your lordship, kindly see. It's not a case of preliminary verification. What Supreme Court has said, your lordship, kindly, these are all, my lord, what they are doing, I do not know. Where the people will go if the police acts like this? Your lordship, kindly see.
That Priyanka Srivastava.
No, my lord, this is.
Lalita Kumari's case, yes.
This is Lalita
Wrongly
Kumari.
quoted, not Priyanka Srivastava. Lalita Kumari's case, not required actually, inquiry not required.
105, just I'm reading.
But they have registered the case already.
But the preliminary inquiry, is it a case of preliminary inquiry?
No, not required, but they have already registered the case. Now they are taking up the investigation.
This is, my lord, what they are trying to do. They are doing hide and seek business.
No,
Because
but
they
they
came to
have
know.
taken up the investigation, no? They registered.
Your lordship, kindly see, the information was given 1/4/2025. They entered into our factory, broken the almirah, took the important documents and threatened to our workers that if you do not give us and if you try to do something, then we shall kill you. Is it not, my lord, cognizable offense?
No, see,
But-
now BNS, certain offenses has to be inquired. Now the BNS has come into force.
No, yes.
Now earlier it was Lalita Kumari's case, it was IPC, CRPC. So direct from 156, there will be only 3 options. You will have to register a case. Now there's
Registration-
another option.
Yes, yes. But registration is a must. Thereafter, you go for investigation because these are very serious
They have
matters.
taken up the investigation.
And let the investigation be gone. And my lord, my
You
only,
don't want me to finish the case?
no, only I request your lordship that your lordship may call for the report from the concerned OC. What
He has
steps they
given
have been
the,
doing.
huh?
My lord, let the case be here. My
He
lord,
has already obtained instructions speedily, 1 day, in 1 day itself. Case has been, yes.
Let me read the instruction. Kindly, let me read paragraph number 1 to 3. Paragraph number 2, kindly see. On receipt of the state complaint from the petitioner submitted to the SP, Soradev, on 1/4/2025, the complaint was forwarded to the officer in charge, Sonari Police Station for necessary action as per law, by memo number 22 dated 2/4/2025 on the next day. That on receipt of the complaint forwarded by the officer, office of the SP, Soradev, the officer in charge, Sonari Police Station, gave a requisition to the additional SP headquarters, Soradev, seeking permission to proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter in connection with the complaint as per provisions of section 173 of BNSS 2003.
Now it's required because
Required.
below 7 years, I think, no? That there has to be a preliminary inquiry
Yes.
under section 173(3) of the
173
BNSS.
logic. Without the 173 figure, then not the permission for preliminary inquiry is granted as paid for. Thereafter, not they have conducted paragraph number 491 to take place. On completion of the preliminary inquiry, the officer in charge, Sonari Police Station, on the basis of the findings and inference drawn from the inquiry, he forwarded the complaint to the officer in the Namtola Police Station to register a case as per law. Since the place of occurrence falls under Namtola Police Station jurisdiction and proceed with the investigation of the case, and accordingly, the Namtola Police Station case has been in the petition, the entire grievance is that on 1/4/2025, a complaint was registered. I have not seen the FIR lodged before the officer in charge of the police station, but the complaint filed before the SP is there. In any case, I have taken the instruction from the SP, and this is the instruction that after receipt of the complaint, they have conducted the inquiry, and now the case is today is 11/4, and the complaint was on 1. And on second, SP has instructed preliminary inquiry. After that, this is done. And the entire prayer in the writ petition is to register the FIR, and that has been taken care of.
So we'll dispose it off then.
my lord, no, your lordship keep it pending, my lord. Your lordship kindly see one thing.
The
Even supposing if it is a case of preliminary inquiry, it should be completed within 7 days. Now, whether they have completed within 7 days, when they have registered the case, these are the things to be seen, my lord. It's not a very clear case. My lord, the police, my lord, my client, they threatened me. You went to DGP also. He asked this pointed question to my client. They are doing nothing, my lord. Only they came to know when we filed before the High Court, my lord, they are saying that we are conducting preliminary inquiry. These are all time-taking matter to give an explanation before this honorable court that we have done something. It's not that way a very clean game. My client said, if the police also not doing anything, where should we go? It's such a heinous crime they have committed. They were about to beat us. They have come with the instrument to kill us even. They have taken our document,
All right, then I'll keep it pending.
got the signature from our workers, my lord.
Yes, all right. We'll keep it pending.
I have lots of
And then, Jenny?
the petitioners, they are in page number 15. But is there why
Yeah.
the read in the nature of Pentamas directing the respondent number 3 and 4 to register a case against the respondent number 5 and 6 for free and to take steps to recover the seized article 20 of 20. Basically, their prayer is to register the case. That has been done. At this stage, when the case is registered, investigation is going on. A sword should not be hanged on the investigating agency. The agency of this writ petition means only to put a pressure on the investigating agency that you investigate, otherwise the court is looking at you. That should be done.
My lord.
Investigation is there, my lord. They have their remedy. If the investigation after the registration of the case, nothing has been done, no investigation. So, my lord, is there.
My lord, why it is done, your lordship kindly,
Tendency of this writ petition will not
because of this case, my lord, they have started something doing. Now, my
I
lord,
absolutely
the
deny that.
recent case, my lord, I will take your lordship to even 173(1) in Imran Pratapgiri, my lord. The Supreme Court has solved the riddle by holding that subsection 3 of section 173 is an exception. This preliminary verification is an exception. Even earlier also the law was there. Now, in an exceptional case, and they have defined, my lord, what are those exceptions, my lord? I will take your lordship to that even. My lord, in case of matrimonial disputes, commercial offences, medical negligence, corruption cases, under those circumstances, you can go for preliminary verification. Here, my lord, what they have done, the incident occurred on 31/3 at midnight. Then, my lord, we filed in the complaint before the SP on 1/4. Now, they did not do anything. When they came to know that the writ petition has been filed, they are saying now we have gone for verification and all that. It's not a case of verification at all. The law is abundantly clear. Now, these are the things by hook or crook they want to delay it, and I do not know what interest they have. The citizens have their right to go to police for some sort of protection. And what protection they are giving us? We are constrained to come before your lordship. And if this thing goes on, I don't understand how we are, as a citizen, how we are protected. The police are supposed to protect us. And these are
But you
their
see the case has been registered now. So
My
what is
lord,
the point of keeping this case pending?
only thing what I'm saying, they will just keep it pending, my lord. I can tell your lordship, they will do nothing because they don't want to do anything. So if it is there, my lord, if your lordship can take the report from the concerned police station that what they are
No,
doing,
no.
what steps
We
they
have
have.
already taken a report from the SP. Another report is not required.
Let it be pending, my lord, so that, my lord, otherwise nothing is going to happen, my lord. I can, if it remain pending, how they are going to be prejudiced by that?
Monitoring of the investigation by the Honorable High Court under 226 is not required.
Yes, circumstances of the case, your lordship
no-
kindly see.
No circumstances.
In which date they have registered, my lord?
Well, kindly,
If it is done today, the preliminary inquiry, if they say from when they have started, have they completed within 7 days?
no, it is,
That
7 days is
CJM can monitor, not me.
it is well, 14 days, under one.
CJM can monitor, not the High Court.
my lord, let it be pending. Let us see how long, my lord. I will not
No,
press.
but we have gotten the
If we
report.
if we get the whatever we want, my lord, I will myself will do the petition.
No, that should not be. Petitioner cannot claim that I have filed an FIR, I should get the desired result, then I will do it.
It's not that, my lord,
Investigation
because
started, Lord.
because the circumstances is not simple circumstances. It was the bounden duty of the police. The moment I have filed this complaint, it ought to have forwarded to the OC, and OC ought to have taken up the matter by registering the FIR. That is the mandate of law. I am not asking something.
Case is registered. Then when, as soon as the FIR is registered, the magistrate will be apprised about it. It will go to the magistrate. And then thereafter, it is the duty of the magistrate, not duty exactly, but the magistrate can monitor the investigation, can monitor.
My lord,
There is a judgment also.
Your lordship is very correct, my lord. What I say that this is not a ordinary case. My lord, as your lordship has seen, they did not register the case at that very moment. It was their duty. They have shifted from the mandate of law. Therefore, my lord, I am not saying that the High Court will monitor. I am not saying that. It's not a question of monitoring. Let us see what is the
No, but without any, why should I keep the case open?
My lord,
It has come to a logical end, so why should I keep it open?
my lord, logical and what I am saying, my lord, this your lordship will find that even the law as on exists now, my lord, the preliminary verification is an exception, and there are certain.
No, it is not given in the statute. This is later part of observation. Now you see
It is by
when
the
the
constitutional
new
tense, my lord.
code has come, the new code has come. So there will be new judgments, then new guidelines. But
No, my lord,
they
even
were the police. They cannot be.
no, Pratapgiri case is also say new law under 173 also. It is stated that it is an exception. And exceptions are those in constitutional bench judgment. This law remains the same like just earlier, my lord.
Only in cases where the imprisonment is less than 7 years.
My lord, difference between FIR registration provision under 154 and section 173 BNSS. The position remains same. This and earlier also it was there was an exception, now also there is an exception. And the exceptional case that I have just read out.
Earlier,
Next-
even there was no exception. Earlier,
Earlier, yes, my lord.
then you, otherwise you go to the SP, you lodge an FIR, you go to the, there's nothing to inquire about. The Lalita Kumari's judgment is very clear about it. So, but
Lolita
now
Kumari,
there's
my
an
lord.
exception.
If I understand correctly,
And then
Lolita
you
Kumari has
don't
said,
have to, actually, now there's
no,
little
verification earlier also.
relaxation.
There was an exception. These are the 5 circumstances: matrimonial case, commercial offenses, medical negligence, corruption cases. Those are the exceptions, and still it remains. So therefore, my lord, what sort of verification was required for that? Is a cognizable offense of highest order, and they are now saying that we are doing the preliminary verification. Is it not buying time? For some reason, they understand, my lord. So that is why I am saying it is not a very ordinary case. Well, the moment your lordship will see that they will be doing like earlier, because these times they have buyed, because saying that we are verifying the authenticity of the cognizable offences. My lord, if you do all these, then how you will protect the citizen? Now, my client, my lord, say the season time, the factory is closed, crores of amount every day they are losing. And these people are still in the factory, my lord. They have occupied a room.
No, the FI doesn't say so.
FIR, my lord,
Doesn't say so. Page number 52. Well, I
they
have
are
to-
not leaving my
I have to-
factory.
I have to-
Your lordship kindly see, your lordship kindly see the complaint. If you are giving protection to these people,
Page number 52.
your lordship kindly see page 52, my complaint.
Look, basically this is a.
On that day, what happened, we have stated, your lordship kindly see, we beg to state that on 31/3/2025, at about 12:15 o'clock at night, Sri so and so, they are the, my lord, respondent 5 and 6, came with vehicles along with 5-6% forcefully entered into our leasehold tea factory, namely Messr so and so, and broke open the lock of our Almira by using overpower and took away all the valuable documents of our factory by giving various life threats to all of us and our workers. And whole night they remained therein and continued their atrocities, including giving the aforesaid threats with abusive languages, and they would grab all our ready stock green tea leaves and other valuable goods, etc., by committing a murder. Thereby, our lives and property, valued more than crores, are under threats of bloodshed. They are proceeding to grab our property by committing fraud. The aforesaid persons even forcefully obtained the signature of our workers on some manipulated papers on the points of life threats to convert into valuable documents to grab our property and also to save their skin. We therefore request you, now these FIR, my lord, the perusal of these abundantly discloses the offense of, my lord, cognizance offense. Now, on that particular day, how can I could have written that they are still living there? On that whole night, they committed the atrocities. And till date, my lord, they remained there. And the police are saying we are verifying. What sort of verification you require under these circumstances? You should have sprung into action at that very moment when you got the information. There is a cognizable offense of the very highest order.
Let him complete. I have my, I'll show.
Yes, I have completed. Let him say.
Yes, yes.
Look, then on 4/4 at page 55, 4/4. Same complaint to the SP again. They have similar complaint has been given to DGP. I am just referring to the SP's copy. Although this is not receivable, they have given a copy. I am just referring where they have said that they are still there. They are just referring to the. I'm reading it. That on 31/3/2025 at about 12:15 o'clock at night, so and so, phone number so and so, came with vehicles along with 5-6% forcibly entered into our leasehold tea factory, namely so and so, and broke open the lock of our Almira by using overpower and took away all the valuable documents of our factory by giving various life threats to all of us. At our and our workers, and whole night they remained therein and continued the atrocities, including giving so and so. with attitude like this, that they would grab all the ready stock, would grab ready stock, green tea leaves and other valuable goods, etc. by committing a murder. Thereby our lives and property valued for more than crores are under threat of damage. They are processing to grab our property so and so. They approach persons even forcefully object the signature of our worker. Exactly same. The Lordship has read the page 52 complaint and page 55 complaint after reading. Same complaint. Now, Malad, they said that they are still there. It is not reflected in the complaint. Malad, basically, what the problem is, Malad, at page 47, they have a lease agreement has been attached here. I think, Malad, this is the problem. Page 47. Some notices given to the other party against whom Malad they have lodged the FIR. See, Bubin Fukon. This is a notice on 3/3/2023. The Bubin Fukon was given a notice by the petitioner. I'm just referring to the point for premature termination of the agreement about which we have already discussed with you. Please see the second paragraph once again and specifically and clearly mentioned to you as under. So, Malad, they have an agreement, lease agreement, and there is some dispute as regard premature termination of the act. They have that kind of a dispute. Therefore, ultimately, these things have been happened. And now police is investigating the matter. Can you see what problem they have? We have been running the steering tea factory since 2015 under a lease agreement for 7 years with full compliance of the sale agreement. This current lease is agreed to be continued till 31/3/2025. However, upon your request, there has been negotiation since last 2 months for premature termination of the lease agreement, but because of not achieving till date to mutually acceptable terms of premature termination, we are facing imminent risk of huge loss and damages. Under this uncertainty clause by the extension of such negotiations, we are now unable to enter into fresh agreement with the tea supplies, which will hamper and adversely affect the production in the current season. So they have some dispute, civil dispute as regards their lease. We are not on that. I have just referred to show that they have some private disputes as regards their lease of the tea factory and tea garden. No, we are not. I am only on page number 52. They have submitted an FIR. Although they have said that they have
Maybe this company is taking green tea leaves and producing tea maybe from the miscreants maybe.
But in the page number 55, which was filed on 4th, they have not said that they're still there. It is not there.
Well, supposing they are still not there,
Nothing has been said.
cognizance of offense has been evaporated or what?
That has been.
Well, police is thinking that way. And if the police doesn't have any private interest,
No.
whether they will do this act,
No.
because now they are saying verification. What sort of verification? The moment you get this sort of information, what is your moral duty apart from
I
statutory
think
duty?
this has to come to a closure, this WPC.
I'll come to that.
I think so.
Well, can you see now under 173?
I will say, my lord, action should be taken against the SP and OC. Because even if your lordship thinks that it is the verification is not required, even then they should close it within 7 days. Have they done it?
No. I'll read
And
it.
when
I'll
from
read
when
it.
they have started
I'll read it.
because if we given the information from 1/4, from 1/4 they were to have completed within 7 days. That is the mandate of law. Whether they respected that, unless they do not have any interest, this thing cannot go in this way, my lord. A person will die, who will be responsible? These police officers, because they did not discharge their duty. And for what reason you were there? When some citizen,
This is, they are only throwing their weight around. I don't think they will kill somebody.
no, but then your
They
lordship,
have been very aggressive, no doubt about
at
it.
night with a vehicle, some people with them, with instrument, you go there, break up in the Almira, take all the documents, and we have informed the police, these are the things going on. Whole night they have done all atrocities. And then they are now saying we have to make verification.
No, but once the case is registered, the magistrate is, now the case has been registered, now GRs, now it will come to the GR register, it will come to the PR register, and then it will go to the magistrate. So now it is the duty of the magistrate.
Your lordship is very correct, my lord. I don't say anything on that.
So I think
But
this has come to a closure. Writ petition has come to a closure.
Your
Now that
lordship
we have
can,
gotten the report,
my lord, your lordship can make an observation.
yes,
The investigation should be done very quickly and in effective manner.
That has to be done. I can't.
I
say-
think
I
that
can't say-
my
I
learned
can't
friend
say-
cannot have any objection.
no, he's not having no objection.
Investigation has to be done as per law. That has to be done. I cannot object to that.
No, I am not saying to him, my lord, your lordship can observe that. For the interest of the justice and to give protection, because unless very dispassionate inquiry or investigation is gone into, nothing is going to happen.
No, the period is 14 days as per 173. Period is 43 days. Now, as per
But it's not a case of preliminary inquiry, my lord. I am not accepting that position.
that has been done, and the period my learned senior counsel has submitted that it is 7 days. No, it is 14 days.
Earlier it was 7 days, now it has been amended.
Now it is 14
But now the question is this,
That has been done within
Within 1 week.
within the.
my lord, I am not
Now the case is.
not on that at all, because it's a not case of going for preliminary inquiry and all that. It's not that type of case.
Okay,
Otherwise,
I'll note down everything.
my lord.
In front of you, I'll dictate.
Note.
I'll note down whatever you want to suggest. I'll note it down.
And your lordship kindly give an observation so that the investigation can come to a correct conclusion.
Yes.
That observation from your lordship.
Yes. Heard learned senior counsel Mr. S. Doctor for the petitioner Motinder Doctor and learned senior government advocate Mr. D. Nath for the respondent, all the respondents.
1 to 4.
For the respondent number 1 to 4, 1, 2, 3, and 4. And this petition has been filed under Article 226 of the Constitution of India. Contending with for a writ of, for issuance of a writ of mandamus or any other appropriate writ or order directing the respondents to register a case against the FIR lodged by the petitioner on
1/4 at page 52.
on 1/4/2025. It is
Yes.
submitted that an FIR was lodged with serious allegations that that Gobind Phukan and his son Sri Ankit Phukan barged into the accompanied by the associates Likidia. Barged into the accompanied by the associates barged into the office of Osini
Factory man.
into the factory of tea factory of MS Osini Bill Tea Enterprise ACHINIBILL Tea Enterprise at Joboka Bagisa Gaon JBAK Bagisa.
Well, factory will be, my lord, it's not Osini, it is, what is the name? No.
No. Just the name of the factory.
Oh, yeah, Manorama Tea Company.
As per the FIR, page 50.
Joboka Bagisa Gaon and broke the Almirah lock and took away valuable documents. And while living, they exercised Nalai while living Nalai. Full stop. It is also alleged that they exercised threats to the workers the entire night and remained in the premises and continued their atrocities. and even went to the extent of threatening to eliminate them, full stop. Despite the offense alleged against the miscreants, no FIR was registered. The learned senior government advocate has obtained instructions and the superintendent of police of Saraidu through the memo number SP/CRD/CON/2025/127 dated 11/4/2025 has submitted that an FIR has been registered after a preliminary inquiry under section 173 within bracket 3 of the BNSS 2023, and the FIR was registered as Namtola PS case number 7 of 2025 under section 329 within bracket 4 bracket close stroke 305 within bracket small a bracket close stroke 351 within bracket 3 bracket close BN single S 2023. The learned senior counsel has raised objections stating that the FIR ought to have been promptly registered without any inquiry, as this case is not a case requiring preliminary inquiry considering the gravity of the offense. I have considered the submissions at the bar. The prayer was to direct the opposite parties to register a case, and thus, as an FIR has been registered as mentioned above, the matter stands closed. With a direction, you want some? You were suggesting something?
My lord, investigation maybe.
With a direction not to with a direction.
A prompt investigation.
There,
maybe.
to take up the no, cannot. Investigation has been already taken up.
Some protection.
No, with a direction to nalage. The investigation taken up has to be. What will be the opposite word of apathy? I'll add something, huh?
As per law,
As per law.
And my lord, the protection to the my client at their cost. Police protection may be given.
that is not a prayer.
No,
I have no instruction.
no, that is, my lord. Any person, my lord, if I am having a threat perception, I can request them and it is given. But in view of this, we have filed a writ petition against them. Unless, my lord, there is an observation, they may not agree to that. And it is not illegal. Is it, my lord, something prayer which I am making? It is an illegal prayer, my lord.
No, I don't think so.
If that perception is there, they can apply for the security for the concern authority.
Concerned authority is SP and OC. Under these circumstances, can your lordship think they will provide?
Threat perception is only for the officers,
Yes.
government officers.
No, in the company.
And then maybe tea company also, that they will provide locally, not from the High Court.
No, the protection, what I'm saying, protection, daily protection because of the circumstances.
No, here
If
I
they-
cannot. Because you see, that has to be dealt with by the SP.
My lord, SP, that's the reason I'm saying with your lordship, that
But
unless
there's
your
no
lordship
prayer
observe,
here.
unless,
SP cannot be doubted like that.
if your lordship, if observation is there, they will provide. Otherwise, due to this, we have come before this honorable court. They will take it as, my lord, that you have gone, even they have sounded us, that you gone to DJP complain against me. And how can we expect that he will provide?
Investigation to be.
Expedition.
I'll include something.
My lord.
to your benefit.
And protection may be given to us.
Protection, no, not protection. There's no prayer, only to register a case.
No, that's
Prayer
true,
is
my
very
lord.
limited. Only register, issue rule and so and so and so and so and to register a case. very limited.
But it is for the protection of any citizen. Anytime one can get it from the authority, but here authority is not going to give us. They have already sounded that also.
I'll add something
All right.
to your benefit.
And my instruction will be to make a part of it.